Andrew, there has been a lot of many headlines recently when it comes to the stand your ground self-defense laws. Can you tell us? I know there are many different aspects involved. There are different kinds of laws in different states. Can you give us your point of view why a self-defense law, in the terms of the stand your ground law, as we know it from Florida from recent cases, why you need that kind of law in this country?
Well, stand your ground in particular, there's a great deal of confusion about, because most people don't really understand its limited scope, and of course it's been politicized as well now for people who want to argue for legal changes to the law of self-defense. The law of self-defense in the United States really has 5 conditions you have to meet to have lawfully defended yourself. One is you have to be the innocent person. You can't have been the person who started the fight. 2, the threat you're defending yourself against has to be about to happen right now. It can't be some future threat that someone claims might happen. It can't be something that's happened in the past. That would just be revenge seeking. The amount of force you use to defend yourself has to be proportional to the amount of force you're threatened with. So if someone pushes you, you can't simply shoot them. One is non-deadly force, the other is deadly force. In a number of states, there's a duty to retreat. So before you can use force in self-defense, you have to take advantage of a safe avenue of retreat. And for all of these, your conduct has to be reasonable. Both you have to genuinely believe it was necessary, and a reasonable and prudent person in the same circumstances would have believed it was reasonable. What stand your ground does is it eliminates one of those 5 elements, the duty to retreat. All the other elements remain in place. So it's common to read in newspapers, for example, that stand your ground allows you to shoot first and ask questions later, or it allows you to use force when you're merely in subjective fear. You're frightened of young black males or something, and you'd be entitled to shoot. But that's not the case. All stand your ground does is relieve you of that duty to retreat. You still have to be the innocent party. The threat still has to be imminent. Your use of force has to be proportional to the threat, and your conduct still has to be reasonable. You just are not required as a legal duty to try to retreat before you defend yourself.
I think for us journalists, but also for juries sometimes, it is very hard to understand all these different elements of the self-defense laws, whether it's stand your ground or other kinds of self-defense laws. We recently had this case, Michael Dunn, who said he did feel threatened by these 4 young black teenagers, and having to act reasonable, as you put it. In his case, he said he felt threatened. He thought there was a weapon involved, but it seems to be hard to prove the contrary. To say, or to prove that he did not feel threatened. So can't you get away with almost any situation if you claim that you felt threatened?
Well, you can try, but you have to convince the jury that your perception of fear was reasonable. Now, in the Michael Dunn case, the only evidence of any threat against him was his own testimony. In fact, that's why he testified in court. Normally in American courts, the defendant would never testify. But if he had not testified, there would have been actually 0 facts and evidence to support self-defense. The jury would not have been read a self-defense instruction. So he was compelled to take the stand for that reason. So we know, as a matter of law and reason, that the only basis on which any of the jurors could have concluded self-defense was his own testimony. The difficulty was his conduct after the shooting was not the conduct of someone who was an innocent party who was attacked. In American law, we call it consciousness of guilt evidence. It's a manner of acting as a guilty person would act instead of an innocent person would act. And what Dunn did in that regard was he fled the scene, and it's always permissible to flee the scene if you think you need to for safety, but as soon as you've achieved safety, you're expected to call the police. And then he never called the police until he was arrested at gunpoint on a felony warrant. That's not the conduct to a reasonable juror. That's not the conduct of someone who really believed that they had acted appropriately under the law. If it were me, for example, and I had really believed someone was about to shoot me and I'd had to defend myself, I would have stayed there and called the police and said, someone just tried to shoot me, I had to defend myself. if I felt so frightened of the circumstances that I had to leave the gas station, as soon as I had achieved safety, I would have called the police and said, someone just threatened me with a gun, I had to defend myself. I certainly would not have driven 2.5 hours home and just gone about my business as if nothing exceptional had happened. So because of that consciousness of guilt evidence, his testimony, the credibility of it was very low. Now we know from juror interviews after the fact that there were only 3 jurors who had even a slight belief in his self-defense. The other 9 jurors did not believe it was self-defense.
But he did get away.
Well, no, the jury hung. So unlike in Zimmerman was acquitted of the crime, so he could never be tried for it again. In the Michael Dunn case, there was no verdict on the murder of Jordan Davis. So the prosecution is free to try him again on those charges, and I'm certain they will try him again. They've said so.
You think so for political reasons, or?
No, I think it's a good legal case. I don't think this is a genuine case of self-defense.
Yeah. And I guess the next headline that we will have to deal with is the so-called popcorn murder or popcorn shooting in a theater. If you look at the law that gives the right to self-defense, could it be enough to feel threatened by somebody because he throws popcorn at you at a movie theater? Is there a slight possibility that this shooter will get away with it?
No, none of the object is merely popcorn. So before you can use deadly force in self-defense, you have to reasonably perceive a deadly threat against you. Popcorn can never be a deadly threat, so it could never justify the shooting. I know his defense lawyers are trying to suggest now that there was some other object thrown. But of course, police were on the scene minutes after this happened, and to my knowledge, no object has been found. Frankly, I think this is just, any technology, any tool of any sort has positive consequences and negative consequences. And I think this is one of the relatively rare negative consequences of someone carrying a firearm for personal protection. I expect as this case moves forward, we'll find out that the shooter in this case, who was rather elderly, may have some mental issues associated with his age and simply was not acting reasonably. And if he was not acting reasonably in self-defense, then it was not self-defense, and he's simply guilty of shooting someone.
But our research showed us that there seems to be a lot of confusion among jurors and sometimes even judges when it comes to the details of self-defense laws. Don't you think this law is, or the different laws in many different states are just too widely worded, so that almost anything could be at least tried to show to a court that you had a reasonable reason for self-defense?
It can seem that way. I mean, really, in just about every state in the U.S., the self-defense laws are based on the same 5 principles I discussed at the start. There's very little variance. The one major area of variance is in the duty to retreat. So there's about 16 states that have a legal duty to retreat, and the rest do not have a legal duty to retreat. The difficulty is, of course, self-defense can happen in the real world in an infinite variety of ways. So to take account of all those different possible fact patterns, the jury instructions can begin to get very complicated. I think in the case of the Dunn trial, just the self-defense portion of the jury instructions was 17 pages long. Overall, there was more than 30 pages of instructions. It's a lot to work through. I mean, you can imagine it probably took the jury several hours simply to read through them for the first time. But it's difficult to see what we would do about that to simplify things, because the world's a complicated and messy place, and people find themselves compelled to act in self-defense at home and outside the home and in their vehicles and at schools and strangers or people they know. It just occurs in so many different ways that the law has to be flexible enough to take into account those various fact patterns.
But again, if you have such a wide range of possibilities to use self-defense as a reason to attack somebody or to shoot somebody, especially from the outside, from outside the United States, it does look as if it could come to a situation where it is Wild West in Florida, and where you have, 5 people in a gunfight, and every single one of them could claim the right of self-defense.
They could. But in my experience, and I read many, many hundreds, perhaps thousands of self-defense cases every year, it's not that hard for a jury to distinguish between what seems like a credible self-defense claim and the vast majority of which are simply not credible self-defense claims. I would estimate that 95% of claims of self-defense that go to criminal trial are rejected by the jury and the person is convicted. Because there's a lot of steps in the criminal justice pipeline, from when the shooting happens to when it's investigated to when prosecutors look at it, where essentially the facts of the case are screened for using their professional judgment on whether it appears to be a case of legitimate self-defense or not. And most of the legitimate self-defense cases, are the ones that very much look like it, never get to trial. The ones that get to trial are the bad self-defense cases. They're mostly people who've acted criminally and they're just throwing up self-defense like every other defense to see what will stick and perhaps get them acquitted. Mm-hmm. But jurors are very, very rarely fooled. Again, I mentioned those 5 elements of the law of self-defense that have to be met. We have to keep in mind, you mentioned it seems like you could attack somebody, but you can't have been the attacker. So if there's evidence that you were the aggressor in the fight, you don't qualify for self-defense as a matter of law. If you use too much force, you don't qualify for self-defense as a matter of law. And usually the bad self-defense cases, those kinds of problems emerge very quickly. And the prosecution only has to prove one of those to the jury. If any one of the 5 is proven to the jury, self-defense disappears. So you could have used reasonable force against an imminent threat, but if you were the aggressor, it's not self-defense.
But there seem to be cases where, there seem to be cases where, for example, during a drug deal or so, it came to a shootout, and it was it was impossible for the jury to figure out who shot first or who was the aggressor. So there is a certain danger that you can get away with relying on the self-defense law.
It's possible, but the alternative would be what? If we move the balance in the other direction, then inevitably what we end up is with people who did legitimately act in self-defense who end up getting convicted and sent to prison. And they met all the criteria. They were innocent, the threat was about to happen, they used reasonable force, their perception of everything was reasonable, they tried to retreat, and we're still going to send them to prison? I mean, that doesn't fit well with American expectations of the ability to defend yourself against violent attack.
So you would not say that, in general, the laws when it comes to the right of self-defense have to be changed or have to be narrowed?
I don't think so. Based on my professional experience, they work pretty well for genuine law-abiding people. I mean, when criminals try to claim self-defense, it's very unusual that they get any traction, whatever. Of course, there are efforts to try to change self-defense laws in this country, particularly with respect to stand your ground, a lot of political argument for it. But the political momentum in America has been exactly the opposite for many decades in terms of expanded gun ownership, expanded rights to carry a gun on your person for personal protection, and for liberalization of self-defense laws, like the adoption of stand your ground statutes, the adoption of self-defense immunity provisions, the adoption of laws that give you a presumption that you were acting reasonably in using force against someone breaking into your house or into your business or into your car while you're in your car. So the entire momentum over the last 20 years has been in favor of more self-defense privileges, more gun ownership privileges, not less. And we can see this even after the Sandy Hook massacre, which obviously was horrific. Nothing happened in terms of changing gun laws or concealed carry laws or self-defense laws, nothing at all.
And why do you think that is?
Because I think the political will and momentum simply isn't there. Now, of course, I've been a member, not just a lawyer, but a member of the gun community really my whole life. I started shooting competitively when I was a child, and I personally, not in Washington, D.C., of course, because it's not permitted here, but in the normal course of my day, I carry a pistol for personal protection, and I have for 25 years. And when I first started carrying a pistol in the 1980s, there were perhaps 6 or 7 states in the country where you could get a license to carry a concealed pistol. Today, it's all 50 states have some provision for allowing people to obtain a license to carry a pistol about the day in a concealed fashion. And I think that reflects the tremendous political shift in terms of how most Americans perceive the privileges and rights of being able to carry a firearm for protection.
Or it could also show us the power of the National Rifle Association and the gun industry in general.
It could. I mean, the National Rifle Association, I think, has about 4 million members. There's over 300 million people in the United States. Even if we reduce that to just voting age people, the NRA is a sizable organization, but hardly a majority of the people who vote. I think if, and of course the NRA has been around for over 100 years, so the notion that their influence suddenly exploded in the 1980s when their membership didn't explode, it's difficult to see how that would work politically.
But Andrew, since you are carrying a gun most of the time,
Mm-hmm.
how, in all these years, how many times were you in a situation where you really thought, good thing I have my Glock or whatever you're carrying?
Almost never. But the analogy I would give you is, of course, you drive an automobile, and I presume every time you get into your automobile, you wear a seatbelt. Or at home, you have a fire extinguisher in case there's a fire in your kitchen. I have a fire extinguisher in my kitchen. I've had it there for 30 years, and we've never had to use it. I don't wake up in the morning and think, today is the day a fire might happen in my kitchen. It's a good thing I have that fire extinguisher with me. It's just a piece of safety equipment in case the unthinkable happens, like a seatbelt is a piece of safety equipment. You put it on, you don't expect to get into a car accident that day. And with a pistol, again, it's the law-abiding person does not get to decide when they're going to be attacked or raped or killed. That's up to the bad guy. So since you can't know when it's going to happen any more than an accidental fire or a car accident, you simply have to be prepared to act accordingly at all times.
But unless I strangle somebody with a seatbelt is not a deadly weapon, and neither is a fire extinguisher.
Sure.
Don't you see that there is a difference, and that the danger is there, that people who are not as responsible as you are probably, and not as well trained as you are, I mean, almost anybody in this country can get a gun. Isn't that, given the number of guns that are available, isn't that a certain danger for the public?
That was a real concern starting in the 80s when states started to really expand their concealed carry program, starting with Florida in 1987 and extending now to all 50 states. So now there are many, many millions of Americans who carry a pistol every day for personal protection all around the country. And we simply have not seen these people use these guns to commit crimes. It doesn't happen. Now, keep in mind, of course, these are people who obtain a permit to carry a firearm. So they submit themselves to a background check. They have no criminal history. These are the law-abiding people in American society. In fact, statistically, concealed carry permit holders have a lower crime rate than police officers. Police officers commit crimes at a higher rate. So it's a hypothetical concern that if more people are carrying guns, bad things could happen as a result, but we just really don't see it.
You mentioned statistics. There are some statistics who suggest that there is a racial element when it comes to some of these self-defense cases. That if you are a white shooter, your chance is higher or better to claim self-defense.
I think the data that's available is very inherently confounding for a number of reasons. One is that almost all white victims of crime are victims of white criminals, and almost all black victims of crime are victims of black criminals. And it has a lot to do with the demographics and where these communities tend to live. White people tend to live with white people and black people with black people. It's, in many of our cities, it's still a highly segregated society. So to take a very small subset of those and just look at the white-black criminal interactions, I think you really don't end up with many data points that are useful, especially in as fact-sensitive an area as self-defense, where so much has to be left to judgment or perception or reasonableness. I know the Tampa Bay Times, for example, did a study in Florida where they looked at how stand your ground might have applied in certain cases. But stand your ground can only ever apply if the person claiming self-defense would have had an opportunity to safely retreat from the conflict, because all stand your ground does is remove that obligation to do that. Many of those cases, like in the Zimmerman case, there simply was no safe avenue of retreat. That's why the Zimmerman case was not a stand your ground case. Just because you call it stand your ground doesn't mean legally stand your ground or retreat was a relevant issue in the case. The same with the Dunn trial. It was not a stand your ground case. Personally, I don't believe that there was a weapon in the teenager's SUV. But if there had been, if you took Michael Dunn at his word and they had a shotgun they were about to shoot at him, there's no way he was going to back his car up fast enough to escape a shotgun. So the Michael Dunn case is also not a stand your ground case. One case that is a retreat case is this Joseph Walker case in Maryland that I mentioned earlier, where these two men had both pulled over their cars on the side of the road after getting angry with each other. And one of them approached, walked up to the other's vehicle, and the other person shot him. To my mind, the person claiming self-defense, the person who did the shooting, could simply have gotten back in their car and driven away when the person they shot was on foot and escaped safely. And Maryland is one of the minority of American states that does impose a duty to retreat. So if that case had happened in Florida, he could have claimed stand your ground status to avoid having to retreat, and that would have been a genuine stand your ground case. But it doesn't happen that often.
You mentioned the study that was done in Florida. Given that, yes, most white people live within white communities, and the same for the African American minority, but when it came to crime between black and white, they did come up with a clear higher percentage of white shooters who were able to claim the right of self-defense in Florida, at least.
But again, if we're talking data and trying to observe trends or patterns from the data, there's been many studies done over the years that show that Americans use firearms to defend themselves on the order of perhaps as much as 2 million times a year. And then we take the Tampa Bay Times, and they looked at, I think it was something on the order of 30 or 40 cases of self-defense. When you take such a tiny sample from such a large overall population of data, I think it's very difficult to generate any really useful information. And of course, they're a newspaper. They're not epidemiological scientists who are doing this study in a rigorous way. It's really looking at a series of anecdotes. Of course, if there is a racial component, that enters the realm of politics, and then people can advocate politically for change to the law. I know in Florida they had hearings in their state legislature just weeks ago or months ago, late last year, where they had held a series of hearings all over the state, every major city, every major county in the state, collected information, collected testimony from citizens who were concerned about the issue, and ultimately the state legislature voted overwhelmingly. I think it was 11-2 or 12-1. Not to make any change in the stand your ground laws. So there's simply no political will there to change it. And stand your ground, I know many people think, well, it's Florida. Florida's kind of crazy, lots of tattoos and old people driving around. And Florida has this crazy stand your ground law. But in fact, 34 of the 50 states do not require you, do not impose a duty of retreat before you can use force in self-defense. And they're effectively stand your ground states. And among those is, for example, California, which is quite a liberal state in the U.S. and very difficult actually to get a concealed carry permit. But in California, you have the right to stand your ground, and you are not obligated to retreat before you can use force in self-defense. In fact, arguably, California is the most rigorous stand your ground state. Not only can you stand your ground, you're allowed to pursue your attacker if necessary for your safety. And that's the only state that allows that.
Andrew, since we're doing this for a German audience,
sure.
I would like to ask you some more general questions about guns here in the United States. You said yourself there are probably more guns than people in this country, and there's a totally different gun culture than in Europe, especially in Germany, also given our recent past. But is it also true that since there is a very strong distrust when it comes to the central government here in this
Sure.
country, that this is one of the arguments that I hear again and again, that if there ever would be a tyrannical government in Washington, D.C., it would be so much easier to fight this government because everybody has, or almost everybody has a gun.
Yeah, I think certainly there's an element of that. I think it goes to kind of the underlying American character, and we're a nation born of revolution. It's one of the reasons the Second Amendment exists, of course. It was written soon after the birth of our country. And we fought that revolution against tyranny. So I think it's an aspect of American character. But I don't think it's relevant to the practical aspects of today's gun culture. Most people don't buy guns today because they're preparing to fight the federal government. But they want those guns for hunting purposes or for entertainment, for sport shooting, competition, and for personal protection. Now, what they don't want is they don't want the government to suddenly decide, we don't want you to have those guns anymore for those purposes. That's why they're resistant to centralized registration or identification, things of that sort, because we see, in fact, we see today that when governments in the U.S. collect that information, it's often used then to confiscate firearms. Connecticut is doing it right now. They just passed, Connecticut, of course, is where the Sandy Hook shooting occurred, the school shooting. In the aftermath of that, they passed new laws outlawing certain types of guns. You had to register them by a certain date. Very few people did that. So now there's many tens of thousands of people in the state of Connecticut who are now felons under the law. And just today I read in the paper that the Connecticut State Police says they're prepared to go door to door and seize those firearms from people. That's not a very government-friendly message for many gun owners in the country, most of whom, of course, don't live in Connecticut, but they grow concerned that perhaps a temporary shift in politics in their state could lead to a similar kind of law and a similar kind of outcome.
But, I mean, we need driver's licenses to drive cars that are not, especially, at least not in general, deadly weapons. So what is wrong with having the government having a little bit more control about where these deadly weapons are and who owns them?
Well, I think there's a couple of ways of looking at that problem. One is there's no evidence that government control of possession or ownership of these firearms has any beneficial effect. If you look at the states and the cities that have the strictest controls, I mean, for many years, of course, in the District of Columbia, where we now sit, it was effectively illegal for anyone to own a firearm. There was some provision for you could own a shotgun or so, but it had to be physically dismantled into pieces so that it couldn't fire. Similarly, in Chicago, it's illegal to own a handgun, much less carry one on your person. Yet D.C. and Chicago are the murder capitals of the United States. So even the most stringent gun control laws do not keep criminals from obtaining guns and killing each other and killing innocent people with them. All it does is keep law-abiding people from having guns. So there's that perception that having the government pass more laws only disarms law-abiding people and doesn't do anything to prohibit criminals from having guns. So you don't get a benefit. If anything, you get a negative because the proportion of guns in the community, in the environment, increases among the criminals instead of the law-abiding. And then, of course, is the element of, well, when the government has this information and has this control, what do they do with it? If we look at the handful of states that still have very rigorous rules for who can have a firearms permit, for example, they don't tend to deny it to everybody. They tend to give the permit to those who are wealthy or politically connected or have political influence. And that doesn't strike most Americans as a very equitable way to handle such matters.
I guess we're sometimes looking at the extreme cases where, like a couple of days ago, a blind man in Florida shot somebody or at somebody in his home. And not only does he not have to go to jail, he gets his guns back by the order of the judge.
Yeah, I know it seems surprising to many people. After the Zimmerman trial, too, of course, they had to give him his pistol back, and they did. But really, it shouldn't be surprising. I mean, if you're acquitted at trial or you qualify for immunity from prosecution, then legally you've done nothing wrong. So there's no legal basis for the government to take your property.
But Andrew, a blind man, I mean, that's like making sure that he can still drive his car.
Well, first of all, blind in the U.S. is used very broadly. It doesn't mean necessarily you can't see anything. It means you're legally blind. For example, he might not be permitted to drive a car, but he might still be able to move around his house. But if I were a blind person and I lived in an apartment by myself and I could hear someone smashing down my front door in the middle of the night and I knew where that front door was, I still have the right to defend myself against that person breaking into my home. They're certainly not there to sell me cookies or to sell me life insurance if they're smashing my door in. There's a reasonable expectation that person is there to do me harm.
Last question, Andrew. If I would have you as my lawyer, and I would be in a situation where, let's say, it's very iffy whether it is self-defense or not. How much better is my chance to get away if I have you on my side?
I'd like to say it's a lot better. It's probably a little better. The fact is, once you're talking to a lawyer because you've used force in self-defense, there's not that much the lawyer can do other than be competent in his practice of law, because the outcome is really dependent on the facts, on what's actually occurred. And it's very difficult to get around those facts. There's often eyewitness testimony, there's certainly forensics testimony, and the lawyer is basically stuck with what you've done. If you've done things the right way, then you have a very good prospect for qualifying for self-defense and being acquitted at trial, or probably not even being brought to trial in the first place. Prosecutors don't like to bring cases to trial that look like genuine self-defense because they're so difficult to win at trial. Unfortunately, if you did not follow the rules, if you made a mistake on one of those 5 elements of self-defense, it's very difficult later to fabricate evidence that you did qualify, and the prospects for being acquitted on the basis of self-defense are very low. I get I get letters every week from people in jail who've read my book on the law of self-defense and say, if only they'd had the book before instead of now, they wouldn't be in jail now.
And are they right?
They're right, yes.
Thank you so much.
My pleasure.